Section 464, how the Legal Services Grant Program is actually implemented. So we've got a few definitions to start off with. Most are pretty self-explanatory. Activity is any changes in the amount of funds in an account. Law enforcement agency covers federal, state, and local government, anyone who is authorized to place individuals under arrest. The providers are providers of legal services, as we've defined in the previous section. The qualified individuals for this program is any person arrested within the United States after January 1st, 2024. So that's 6 months after the tax goes into effect, to give the program director time to accumulate funds and set up the voucher program. And voucher doesn't have to be any physical voucher, just it could be a card, a code, any means of access to the Legal Services Grant Program. All right, subsection B establishes the actual grant program within the Office of Justice, and an Assistant Attorney General will oversee it, with a director who will award these grants, carry out these grants using the funds that we just talked about. Some of the startup funds for this program come from Section 559E of Title 16, which was drug war funding that will no longer be obligated when the federal war on drugs ends. So it'll be repurposed to establish justice in this way. And the purpose, the duties of the functions of the Legal Services Grant Program is to establish a program where qualified individuals receive a grant for legal services that they can use from any participating provider. Subsection D in general sets up how this program works. The Legal Services Grant Program will preemptively establish individual accounts for legal services grants prepaid with $200. So you could imagine essentially sending out prepaid gift cards to law enforcement agencies, if not physical gift cards, the codes or the access codes and things like that, in order to access an account within the Legal Services Grant Program. And then the next thing is they'll establish standards for how law enforcement agencies should promptly distribute a voucher to any individual arrested, notify the Legal Services Grant Program of the amount, the name and birthday of the individual provided a voucher, a summary of the charges, and the number of vouchers that they have left. So we've got an ongoing accounting of how these are distributed. The Legal Services Grant Program will ensure that the amount in the account is at least $100 plus $200 for any felony charge, plus $100 for any lesser charge. So if someone is charged with just arrested for a misdemeanor, then that the $200 that'll be pre-funded into accounts, $100 plus $100 for a lesser charge. If there are multiple misdemeanors, multiple felonies, then the amount of money put into their account would increase as needed. The next duty for this department will be establishing the voucher redemption program. They'll set minimum standards for provider participation. And in general, anybody who pays the legal tax is automatically a participating provider of legal services, but they would have the option to opt out. What this does, though, by setting minimum standards for provider participation, makes it possible for people, organizations that aren't necessarily members of the Bar Association, that aren't necessarily lawyers who have graduated from a law school and have a degree, but who it opens the opportunity for, if they're able to demonstrate minimum standards of legal knowledge and an ability to help people in these legal situations, they could be set up as a participating provider and be eligible to redeem these legal services voucher. As they set up this program, also will make sure that there is widespread acceptance of these vouchers, and that participating providers are promptly reimbursed without fees or charges for the value used by the account holder. So if you've got your $200 voucher and need some legal advice quickly, what are you facing? This is the opportunity for somebody who's recently arrested to be able to get a lawyer on the phone with some spending money in hand to get the answers that they need, rather than what we have now, which is maybe waiting until an arraignment or later before being assigned a public defender. Additional duties here: establishing a process for topping off the account if additional charges are filed later, establishing a website so individuals can search by zip code for participating providers, check their account balance, and make transfers to other accounts. Establish a program where qualified individuals can transfer funds and accept a transfer of funds. The department shall ensure that this program is accessible to incarcerated individuals. Most estimates are that about 3% of incarcerated people are innocent, and there are many, many people who are stuck in prison and can't afford legal representation to get their cases reviewed. And so by opening up a process by which people can donate their vouchers for legal services to other individuals in need, we'll create a process by which incarcerated people can then get funds to get their cases reviewed and better seek justice. And then they'll also be responsible for, paragraph 8 here, issuing a proposed draft of legislation that, if enacted, would further clarify and implement the provisions of this section, including what additional grants should be provided for court appearances at other milestones. So whether this could supplement or how this would relate to the current public defender programs in different places. And then also establishing funding thresholds so that people who are brought into court for non-criminal cases, like family court, like small claims court, and other civil proceedings, could potentially have access to legal representation as well through this program. Also clarify that there's no cash rebates, that if the grant isn't touched for a year, if there's no account activity, then it goes back into the trust fund, and that grants are not income. They're not taxable income. And that's clarified by amending this section of the Internal Revenue Code to clarify that legal service grants aren't income. And so that sets up a framework for a fee and dividend model for legal services that will make legal services more accessible to Americans who need them and help us in our duty of establishing justice. And with that, Mr. Chair, I think that concludes my testimony on section 464, and I'd be happy to answer any questions.
Thank you. I have a question. Is that enough money? $100, $200?
It's a place to start. So no, $200 is certainly not enough to represent someone all the way through a criminal proceeding, but it's about an hour of time. And one of the other things, like we said in the findings, the goal is to create a new market for legal services, so that if you are a young lawyer who doesn't have rich clients and things like that, and you would like to help to be a steward of justice, to actually fight for the people who need legal representation but who don't have any money, now you've got a business model where you can have provide short-term advice to different clients. Once the program starts, the numbers and things can be reevaluated. This seemed like the place to start.
Cool. And you had mentioned that currently public defenders, a lot of the funding comes from states. How do you see the enactment of this at the federal level affecting potentially how states approach funding?
It's a great question. And there's a lot of variation right now in the way that states approach funding. Some of them do it all on the state level. Some of them do it they don't do it on the state level, and it falls to the local communities to fund their public defender programs, which means that the impoverished communities that have the greatest need for legal legal representation for public defenders are the ones least likely to be able to afford it. And so as a national program, hopefully we can set some minimum standards at least, and hope that sort of a rising tide lifts all boats. I don't know how specific states will react to this sort of program.